enforcement officials are people who have been involved in enforcement actions against multi-level marketing companies. Our first speaker is Katie Daphne. She is an assistant director in the Federal Trade Commission's Division of Marketing Practices. And let me make sure that I can, okay, there she is. Hi,
Thank
Katie.
you, Doug. Can you hear me well?
Yes.
Okay, great. I want to say thank you, first of all, to the organizers. I am thrilled to be here speaking with such an interesting and esteemed group of people on such an important topic. And because you've already heard about some of our current and recent cases at the FTC, I thought it might be good for me to take a step back and talk about my 4 top takeaways from my time working on pyramid law enforcement at the FTC. And so again, as folks have said, these are my takeaways. I'm not speaking on behalf of the commission or any commissioner. So takeaway number 1, and you may have gathered this already, FTC leadership does care tremendously about this area. People may or may not know that as federal agencies go, we're a relatively small one, especially given the size of our mission, which is about competition and also unfair and deceptive practices writ large throughout most of the marketplace. But even if you just look at our current law enforcement right now, we are litigating against Mlmr, as was mentioned, and Success by Health and Jay Noland. We sent out the series of COVID-related warning letters to MLMs. We also have cases against recruiting-based or MLM scams where we don't specifically allege pyramid, but we are trying to, shut down these scams. And while we can't comment on ongoing investigations, it's also fair to say that we're paying attention to MLMs and we're watching for companies that are taking advantage of consumers. And of course, especially true during this health and economic crisis that we're facing right now, we want to use all the tools in our arsenal to protect consumers. And so I wanted to mention that we have something new. Congress passed a law in December of 2020 called the COVID-19 Consumer Protection Act, which imposes monetary penalties on violators. So for the duration of the coronavirus health crisis, it's a violation of this new law to engage in a deceptive act or practice that's associated with the treatment, cure, prevention, mitigation, or diagnosis of COVID-19, among other things covered by that law. And also because foreign law enforcement has come up in that last panel, which was so interesting, I did also want to note that as long as foreign investigation involves fraudulent and deceptive commercial practices, we can do investigative assistance as long as the request meets the other statutory factors and subject to the FTC's discretion. So this is true even with criminal prosecutions, and we often do work with law enforcement partners, both at the state level, other federal partners, and internationally. On this law enforcement first takeaway here, the last thing I wanted to say is that a critical area of need from my perspective is our need to continue working with experts in this area. Law enforcers who work in this area know you do rely sometimes on expert opinions and work. And there's a surprisingly limited amount of research in this area. So of course we appreciate what there is. But if you're a potential pyramid researcher, please feel free to reach out to me because we have a lot of ideas about interesting research questions. And given the complexity of this area and also the consumer harm associated with it, there is a lot of work that that's incredibly interesting that could be done in this area. And I'll be offering for various people to reach out to me during this presentation. So let me say right now what my email address is. It's just my first initial and last name, kdaffin@ftc.gov. So I'm happy to hear from you. And I'll mention a few other things that I would love to hear about besides research. Let me go now to my second takeaway, which is that law enforcers, legislators, and others should know that in pyramid law, every word matters. And a lot of us know this already. So I'll throw out a few examples and then talk about one particular example that troubles me. So when we look at a pyramid scheme, what does the term retail sales mean when a particular company is using it? What does the term customer mean? Even that can be complicated. If you're looking at an earnings disclosure in an MLM context, is that reporting only on active participants? And if so, what do they mean by that? What should be counted as personal consumption, as came up on the prior panel? The FTC and other enforcers look beyond labels and jargon to what is actually happening in an organization. And this can be a difficult project, but that's what we do. That's what we have to do. And we're up to the task of drilling down and gathering evidence about how an MLM program actually operates and whether that MLM is an illegal pyramid scheme. And as was mentioned in the previous panel, we do rely on, consumers who have experience with the MLM coming forward to help us understand what's happening, in addition to other tools such as undercover work. But that perspective is critical to us. So let me give an example where every word matters. And it's already come up today. The word primarily is often thrown around in this context. People will sometimes say that the definition of a pyramid scheme in the United States is that it offers rewards based primarily on recruiting rather than on retail sales. And I just wanted to put out a call for people to watch out for this word. It has come up in litigation regarding pyramids, but it is not the law. And as Commissioner Phillips and Andrew Smith both mentioned, the law is set forth in the Coscott case. And I'll just say one more time what the standard is, and you can listen out to see if the word primarily appears. Okay, pyramids are characterized by the payment by participants of money to the company, and in return for which they receive, 1, the right to sell a product, and then critically, number 2, the right to receive in return for recruiting other participants into the program, rewards, which are unrelated to the sale of the product to ultimate users. So that's talking about true consumer demand. The word primarily isn't there, okay? It has been used in cases where we wanted to show that we thought we were bringing a very easy case because here the rewards were based primarily on recruiting, but that doesn't mean it's the legal standard. So moving on to my third takeaway, I wanted to note, and part of this is because I think the topic of anti-pyramid legislation might come up. I wanted to note that in my own view, the perfect pyramid safeguards are not the answer to really achieving meaningful change in this area. And just to give a little bit of history here, this concept for me starts with the Amway defenses. Many of you know that the FTC lost a pyramid case against Amway, in part because Amway had certain safeguards in place to protect consumers from pyramiding related harms. But since that point, courts have acknowledged that every case has its own facts, and the safeguards that were described in that Amway case do not always protect consumers from the harms of a pyramid scheme. And I just wanted to note that in my view, in subsequent years with our law enforcement, we have seen changes in the MLM industry that do appear to be designed to apply protections for consumers. So for example, taking some steps to track purported retail sales, making different categories between people who are business opportunity participants and people who are customers. Some attempts to curtail inventory loading, which is what was mentioned before, people buying a bunch of products, not because of true personal demand, but because of the incentives within the program. And yet, in some cases we see that it's possible for a company to have these kinds of things in place and still continue to operate as a pyramid scheme. And so we see time and time again that window dressing can be layered on, and yet you can still have a pyramid thriving underneath those layers. So the field is always changing, and we know that pyramids will try to continue to find new ways to update their business practices and try to disguise their law violations. And I think that will be especially true if any new safe harbors come into place and are enacted as a matter of law. Okay, so on to my last point. My takeaway is that consumer education is absolutely key here. And I'm so happy that there are so many people involved in this conference who are focused on this aspect of things. And I would love to keep this conversation going. My perspective is that we at the FTC have returned over $11 billion to consumers as an agency in the past 5 years. But we can rarely make people whole. And so as someone who's myself worked on some of these cases, it's very frustrating when you put all this time in, and sometimes you can actually stop a scam, get money back, return it to consumers, but you're still not making them whole. And it would be so much better to prevent losses from occurring in the first place. So what we've seen is that consumer education messages can be really powerful, especially if they're coming from a friend, someone that you know. We also see that everyone wants to be the hero of their own story, and that it can be really powerful when people who have lost money to pyramid conduct can use their knowledge about pyramid schemes to educate and empower others to go out and also spread the word. So one thing I wanted to note here is that we have revamped our consumer education recently. We tried to make it more concrete for people and more helpful. So if you haven't taken a look at that, I would urge you to do that, and I really hope it's useful. You can find it at ftc.gov/pyramids. And if you think it should be improved and there are particular concrete helpful messages that we should be helping to disseminate to consumers, please feel free to let me know. I also wanted to say that if you're looking around our website and find things that are useful, none of it is copyrighted. Our whole goal is to get the word out to people. And we have a lot of blog posts and other things that also talk about pyramid issues. Feel free to use any of that and help spread the word, and we would really appreciate that. One other thing I wanted to note is that we're also really interested in ideas for how our consumer education can better reach communities of color and lower income communities, or others who are being particularly targeted or affected by pyramid schemes who may not know how to find us at ftc.gov. And so I'd love for you to reach out to me directly if you have ideas about that. And then if you are working to educate consumers, please do encourage them to file a report at reportfraud.ftc.gov. I'm really happy to say more about that later if we have time. I know my time is up, but it's absolutely vital for us and the many other law enforcers who use that data every day. Thank you very much.
Oh, thank you very much, Katie. That was great. Let me move on to our next panelist, Joe Kanata. Joe, thank you for being here. Joe is an Assistant Attorney General in the Washington State Office of the Attorney General. He worked extensively on the LuLaRoe case. I think we'll be hearing more about that. Joe, without further ado, let me turn the baton over to you.
Thanks, Doug, and thanks, Katie. There's a lot of great ideas there. I'm going to start by first talking a little bit about our office. It's funny to hear Katie mention that she feels that the FTC is small. From the state perspective, we feel we're even smaller. So as Doug mentioned, I'm in the Consumer Protection Division of the Washington Office of the Attorney General. We have over 100 people in our division, so we're relatively, we're not big, but we're not small. Over 30 of those people are attorneys. And we recently, again, as Doug mentioned, wrapped up our very first pyramid case by settlement with LuLaRoe. And I think the fact that that's our first case in this space highlights, an important point I want to make, which is that, I know everyone here is really interested in MLMs, but it's just a very, very small piece of what our division does. Our mandate is much broader. As the name of our division suggests, our mandate is to protect consumers, and that's a big job. And we go about doing it in two ways, similar to what Katie alluded to. The first is just through education. We try and arm people to have the information they need to protect themselves. And the second, of course, is to try and stop or change activity we see out there that's potentially unfair, deceptive, or otherwise harmful to people. And our primary enforcement tool is Washington's Consumer Protection Act. So that's what we look to first. MLMs, of course, like any other business, have the potential to violate that Consumer Protection Act. So if we're looking at an MLM, we're probably going to first ask ourselves more general consumer protection type questions. And for MLMs, that's going to be something along the lines of, are folks being misled about the income potential? So that's going to be the first and primary question we think about. And of course, MLMs are different than other businesses and have the potential to violate Washington's pyramid law. So we'll also look at that. So I just wanted to start by kind of throwing that out there, and that while everyone today is really interested in the pyramid piece of things, for us, our focus is probably going to be more, we're going to be more interested in the general CP claims first. And we view the anti-pyramid statute as just an additional secondary tool that we have at our disposal. So that's what we do. We, most people understand that. And a lot of people what they don't understand is, how we go about doing it. Either don't understand it or just don't know, because it's not necessarily obvious. And so I want to turn a little bit and talk about some of the factors we think about when thinking about bringing in cases.
Thanks. I was going to ask you that question, Joe. What goes into that? Because I think a lot of people are going to be fascinated by that.
Yeah, the top two questions we like are, what exactly do you do, and how do you do it? So, and especially since there are multiple regulators in the space, it's you have the FTC. So why do we need a state regulator? Things like that. So I can turn to that for sure. There isn't really a playbook, I would say, and there isn't really a science to it, but there are common ways investigations or activity comes to our attention that leads to investigations. And the main way that I think we learn of things is directly from consumers. Katie encouraged people to submit complaints to the FTC Sentinel database. We also have a Washington database for complaints, and also are always encouraging people to submit complaints there. Our website, you can submit by mail, by email, through an online submission form, and I think over the phone. And it's just, for us, that database is a really rich source of information about types of behavior that might be problematic, how many folks might be concerned about a particular area, and sometimes we can even learn about how companies might be responding to the complaints through that process. So we rely heavily on that. And we will also look to the FTC's database as well. It gives us a sense of whether or not the problem is local, national, its impact on Washington. And we're also relying on what we see out there ourselves. I think this might be an area where we differ a little bit from the FTC. Obviously, the FTC has regional offices across the country, has a national focus. For us, all 100 people in our division, we all live in the greater Seattle area and are out in our communities hearing about things and seeing things and experiencing things as consumers. And so that often triggers or brings business conduct to our attention. And so those are the biggest sources of information, I would say, is, what is the public telling us? what are they experiencing, and then what are we ourselves experiencing as members of the public. There's some other areas, and this is not an exhaustive list, but there are other ways we learn of things. We monitor media, particularly social media these days when we're all in our homes. There are referrals from other agencies. Our office participates in multi-state investigations. This is another area I think that's different than the FTC. There's a National Association of Attorney Generals. It's an organization that organizes joint multi-state work. And so through that organization, oftentimes several states will work together to investigate an issue. And that can lead to either joint cases, it could lead to states peeling off and doing individual cases. But that's another way we learn of things and bring cases. But I'd say the bottom line is, like Katie said, for all the consumers out there, please use the submission options you have available. There are only so many of us, and we really rely on the public to be our eyes and ears about what's going on out there. And on a substantive side of things, once we learn of things, different attorneys have different interests, but some things that might get more attention than others based on what attorneys looking at it are, is there a particularly large impact on Washington? Are there certain populations involved, vulnerable populations that are impacted? That is often concerning to a lot of us. Does the activity seem to target particular populations? And populations, could be anything, but common ones are, the elderly. That's often a priority for people. Low-income victims, veterans, and children. Those are all areas and populations that are concerning to many of us, and that might get more attention when it comes through the hotline. So just a wide way of ways we learn of things that can lead to our interest or concern in a particular area.
Which of those factors that you're talking about, what were present in the LuLaRoe case that made you guys decide to take them on?
So I wasn't. Yeah. So actually, this is a good reminder that I should give my normal disclaimer of all the opinions expressed today are mine and not the agency's. I actually wasn't with the office during the investigation, but I've heard generally how it started. And kind of like along the lines of what I just mentioned, I think from what I've heard, the primary driver was consumer complaints. We were getting a lot of complaints about different business practices and people's experiences in a wider range of topics, the breadth of which was surprising. Everything from product quality to their experiences leaving. So I think that was, from what I've heard, that was the number one factor. I have also heard, I also know that one of the attorneys who was investigating was an active social media user and was on the Nextdoor app on her phone and was seeing a lot of posts in her neighborhood about folks, LuLaRoe consultants going out of business. And so, that was concerning. That it seemed to be that there was a lot of people who were not able to sell product and were having to sell it at a huge loss and were essentially closing down their LuLaRoe shops. So those, consistent with our general approach, were the ways that it came to our attention. So,
were there other states that were looking at this? I mean, did you reach out to other states to see what they were doing with regard to LuLaRoe?
I don't know that one way or the other. When I came in to the office, we were already in litigation. So I wouldn't be surprised if there was discussions with other, because we often get, we often hear things via referral from other states or even other internal Washington agencies. So I mean, it's very common to hear about things from other people. And so I wouldn't be surprised if there was some discussion with other states to see, kind of what their thoughts were, or if they were getting complaints as well.
Thanks very much, Joe. I think I know there's going to be more questions, but I think we should move on to our next speaker, who is also from your office, Ben Brycex. And Ben, hi. I think from Ben, and I'm sorry for my timer not being muted here. I am trying to be vigilant here. But Ben is an attorney, assistant attorney general in the Washington State Office of the Attorney General. He worked on the LuLaRoe case, and I think he's going to tell us a little bit more about the statute that he's had to deal with in that prosecution. And Ben, go ahead. I'm going to get myself off the screen here so you have more room to teach us. Thanks.
Great. Thanks, Doug. And thanks to the organizers for putting together this great event. Like Joe, I need to give my disclaimer that the views and opinions I'm about to express are my own and not necessarily those of the office or the Attorney General. And also because I'm going to be diving a little deeper into Washington's anti-pyramid statute and talking about some of the elements in there. I also just want to give a disclaimer that I'm not providing any legal advice. If you have specific questions about this statute, consult your own attorney. So with that out of the way, I am going to talk about Washington's Anti-Pyramid Promotional Scheme Act, which is the law in Washington that outlaws pyramid schemes. And hopefully this conversation is going to be relevant to even those of you that are outside Washington State, just because our statute is actually very similar, in some cases nearly identical to statutes in other US states that outlaw pyramid schemes. So hopefully this will be useful context for everyone. So with that, I am going to try to share my screen and put up some definitions. So hopefully everyone can see this. And apologies in advance, I'm going to read this definition to you. It's the only time that I'm going to read legalese at you during my part of this panel. But Washington has a law outlawing pyramid schemes, and the legislature has defined pyramid schemes to mean any plan or operation in which a person gives consideration for the right or opportunity to receive compensation that is derived primarily from the recruitment of other persons as participants in the plan or operation, rather than from the bona fide sale of goods, services, or intangible property to a person or by persons to others. Now, there's a lot in there. That's a long sentence. It's got some language that differs from the federal law that you heard Katie describing earlier. So the word primarily does appear in this definition. I want to break it down and talk about some of the elements here. The first is this idea of consideration. So in order for something to qualify as a pyramid scheme, the participants have to give something up in order to participate. And you guys might be familiar with the general legal concept of consideration, giving up something of value in exchange for something else. But in this context, the Washington legislature has given us a really specific definition of what consideration is for purposes of pyramid schemes. And it is the general idea of giving up something of value in order to participate, but there are three exceptions that are unique to the pyramid scheme context. So the first is buying essentially sales aids or display materials. You know, the money that a participant spends on that is not considered consideration. This second exception, the purchase of goods or services subject to a bona fide repurchase agreement. I'll talk a little bit more about that in a second, but that can be a fairly big category of the overall amount of money that a participant is paying to an MLM or a potential pyramid scheme. So it's essentially any of the wholesale goods or services that the participant is buying in order to sell to somebody else, as long as it's covered by a repurchase agreement. That money is not consideration. And then finally, the final exception is time and effort. So people's time has value, but to the extent that you're sort of giving your time to the MLM, that is not considered consideration for purposes of determining whether a pyramid exists. So this second category I mentioned, I want to get back to it. It can be a fairly large category in terms of the overall money that a person spends in participating. And the Washington legislature has defined what a bona fide repurchase agreement is. And I'm not going to read this definition, but to paraphrase, it is essentially, there has to be a policy in place that if a participant wants to exit, they can write in and have the MLM buy back essentially all of the inventory that that participant bought in the last year, subject to some exceptions. And they have to provide at least 90% of the purchase price as a refund. So I want to talk a little bit more about those exceptions. Obviously, there's the 1 year limitation. So merchandise that's older than a year does not need to be refunded. And then this currently marketable inventory language, you might be able to tell, introduces a little bit of potential for more exceptions. So for example, if the company is selling food or some other consumable product that has a shelf life, if that shelf life has expired, the company doesn't need to buy back expired products, stuff like that. But I would add that I view this as a very strict and exhaustive explanation of what is in a bona fide repurchase agreement. And so to the extent that a company is really stretching the limits of that currently marketable language and really limiting the inventory that is eligible for a refund, particularly if they're doing that and not being fully transparent with participants about those exclusions, that's a red flag. And then to the extent that a company is imposing other deductions or reductions on the refund that push that number below 90%, that's another red flag. Those are both areas where, we'll look closely and there may be a potential violation of the statute here. So this is a really deep dive on consideration. I want to go back to the statute. And the second thing I want to talk about is this right or opportunity language, which means what it says. This statute prohibits offering the right or opportunity to earn compensation derived primarily from from recruitment rather than retail. And that means the possibility of receiving income derived primarily from recruitment. So we'll look at how income is actually derived. And we'll also look at how income possibly could be derived given, how the firm's compensation plan works. The next thing, and sort of the last element that I want to talk about is this issue of primarily and weighing and comparing income that's derived from recruitment relative to income derived from retail. And the two things that I want to point out here are just that this statute does not require us to aggregate income across the entire consultant or participant workforce when we're doing this weighing process. So we will look at individual compensation and do that comparison, find out if there are people within the organization who are earning more from recruitment rather than retail. And the second thing is this issue of bona fide sales of goods. And Katie talked about this a little bit. We take a similar sort of perspective on this, that a bona fide sale is one that is based on genuine consumer demand. And so a consumer that really wants to purchase this good or service, as opposed to participants buying and selling from one another or selling to family and friends for the purpose of unlocking certain rewards or meeting certain compensation benchmarks or to advance within the organization. that latter category of sales, those are not bona fide sales for purposes of comparing where the income is coming from. And then zooming out, just to talk about the statute as a whole, I think it's useful for folks to know that we will look at both how things exist on paper. So what are the company's policies and procedures? What is their compensation plan in a formal sense and how it's written down? And whether any of that violates this statute and crosses the line from being a permissible MLM into being an illegal pyramid scheme. But we'll also look at how the company operates in practice to the extent that that differs from what is written down on paper. So if the company has informal policies, unwritten policies or procedures, or they do things that are contradictory to what they have written down in their formal procedures, all of that is going to be relevant to our assessment of whether a company is operating as an illegal pyramid scheme. And then finally, I'm going to talk a little bit more about the LuLaRoe case. I know Joe already gave everybody some context, but that is just a recent example of an enforcement action that Washington State has brought under this statute. There were multiple claims in that case. We were alleging violations of both the Pyramid Scheme Act and of our General Consumer Protection Act. And those Consumer Protection Act claims were based on our allegations about income claims and other representations that we were alleging that LuLaRoe made about how much money people could earn and things like that that were misleading and deceptive. And that case, was in discovery. LuLaRoe filed some motions to try to eliminate the Pyramid Scheme Act claim and some other claims about midway through the case. We went before a judge and fought that out, and we prevailed, defeated those motions. The case was set for trial, and then before trial, the parties settled the case. That settlement involved some monetary terms and also some injunctive terms. So the monetary element was $4.75 million, I believe, to the state of Washington. And the vast majority of that is going to go towards restitution for Washingtonians who signed up and we allege lost money as a result of participating. So, some of those losses will be offset. And then the injunctive piece was essentially some promises that LuLaRoe would change some of its business practices going forward. And so that's just a recent example of us enforcing the statute and applying our view of the statute. So that's all I have. I know I'm almost out of time. I'm happy to answer questions at the end, and just very glad to be a part of this panel. Thank you.
Well, thanks very much, Ben. And I know I'll have some follow-up, and I'm sure there'll be some other questions. So thank you very much. But let's move on to our next speaker, Jacob Gilbert. Are you, yeah?
Hi.
Hi, Jacob.
Good morning.
Jacob is an attorney with the Consumer Fraud Bureau of the Illinois Attorney General. He worked very extensively on the Herbalife case, and I think some other cases of interest to the attendees today. So without further ado, let me turn the podium over to you, Jacob. And thanks very much for being here.
Thank you, and thank you for inviting me to speak today. It's an honor to present. I'll start with the statement that everyone who's preceded me has had to say as well. The opinions and statements are my own and not necessarily those of the Office of the Illinois Attorney General. So just as an initial thing, although this I guess would sound like it is on behalf of the office, we encourage anyone who believes that they are a victim of a pyramid scheme or any other type of consumer-related fraud to file a complaint with our office as well, especially if it's an Illinois-related business or if they're an Illinois consumer. But even still, if it's a business that's affecting Illinois, those are complaints that we would be interested in receiving. Sort of the same, we probably have a similar consumer complaint ability to receive consumer complaints as you heard from the state of Washington, and likewise with the FTC. Just to give a little background on my bureau and where I work, is very similar to what Joseph Kanata said about the bureau in Washington as well. So I'm within the Consumer Fraud Bureau at the Attorney General's office, and we are not just a pyramid-centered bureau. In fact, our bureau covers a very wide variety of consumer-related matters, everything from electronic cigarettes to auto fraud, construction fraud, payday student lending, lending relating to the purchase of real estate, fraud perpetrated by people providing unauthorized immigration services, fraud that doesn't even have a well-defined name yet. I've actually had a fraud case that involved the sale of pigs. So it's, we're a bureau of about 25 or so attorneys covering a wide variety of topics. So, but pyramid is definitely an issue that we have addressed in several matters. What I wanted to cover today are mainly warning signs, both that and red flags that in the middle of our investigation, when we're looking at a company that pop out for us, but I also think for those that are attending today that are consumers that are looking at whether or not to join a multi-level marketing or similar direct sales operation, what should jump out at you? What jumps out at us? And I'll say that these aren't necessarily signs that something is a pyramid scheme, but these are definitely things that if you hear them or things that you should think about and consider when you're looking at whether or not to take advantage of a business opportunity of any type. I should also note that, again, as a general purpose consumer fraud bureau too, when we look at a company, even if a consumer files a complaint that's like, this is a pyramid scheme, we don't, as I assume with the Washington Attorney General's office as well and other Attorney General's offices that I've worked with in the past, we wouldn't necessarily just only focus on the pyramiding aspects of, or the alleged pyramiding aspects of a company, but we would also look at all the actions of the company, because again, our statute in Illinois, the Consumer Fraud Act, is pretty broad, and so we would look not just whether it violates our specific anti-pyramiding component of our Consumer Fraud Act, but also whether or not there's omissions, misrepresentations, or other actions which would generally meet our definition of unfairness in Illinois. And so just some things that have sort of in the course of my investigating, from both meeting directly with consumers who are affected by pyramid schemes, but also from interviewing and deposing individuals who were active participants and didn't necessarily consider themselves victims of, but rather consider themselves successful participants in what we believe to be problematic marketing operations, I'll say. But what did they say that sort of gave us pause? And so just sort of to step back first, if you are a consumer, again, to couch this under another way of framing it, if you're looking at something that's an opportunity that presents itself as a business opportunity, you would obviously do your due diligence first. You wouldn't want to just leap in and say, I'll just throw whatever money it takes and I'll figure it out as I go. So a lot of the advice and the warning signs that I'm giving fit into that. You wouldn't want to just, your neighbor tells you, hey, I'm making a lot of money doing this. You wouldn't want to just jump headfirst in and start throwing your money into it, not knowing how deep you're going to have to throw it. So a lot of this advice is sort of geared towards that as well. So as I'm looking at a company that has been alleged to be a pyramid scheme, like a complaint has come in or multiple complaints have come in, and it's something that I've been directed to investigate, what's going to jump out at me? What often jumps out at me to dig deeper? And one of the first things that leaps out to me usually is the terminology and the language. If you're looking at the way that this business opportunity is being presented, and it involves this whole new category of language that requires your own separate level of understanding to follow what's being offered, that for me can be a little problematic. It's definitely already setting up a framework where it's hard for an individual to understand what is being offered to them, and what will the costs be what are the costs that will be involved in the opportunity, and what are the requirements being placed on them, and understanding how those requirements might affect your ability to participate. I would also advise people, and again, something that we would look at too, is consider the product that's being offered. If you're going to be selling a product, a good thing to ask yourself is, would you buy it? Would anybody buy it? Is it a product that is unique or highly ubiquitous? Are you just selling another brand of water? And at that price, is it something that's going to sell? Is that a price that's going to sell? How hard is it to find that product? If you're being given the opportunity to sell a product that is sold at every single corner store, but now you're going to be given the opportunity to try to sell it to your neighbor, that might be something to think about. Is that something that I'm going to be able to compete with the ability, to compete with, brick and mortar retail sales that are everywhere you look? It's sort of like the idea of, would you open up a fast food, if you're being given the opportunity to open up a fast food restaurant that sells cheeseburgers, would you open it up you wouldn't want to open it next to another cheeseburger fast food restaurant. And during one of our investigations, we sort of ran into that issue with consumers, some who deemed themselves successful and some who considered themselves victims, but both would say, well, I was looking into selling it, I knew that it was being offered for sale, on the floor above me and on the floor below me in my apartment building. And I knew that it was being offered for sale across the street. So I thought I'd get into it. And if that were a restaurant and you were like, I'm going to sell cheeseburgers, and they're selling cheeseburgers above me, below me, and across the street, you'd likely pause and say, maybe this isn't the right market to enter. Obviously, that is, from an enforcement perspective, also sort of raises a flag to us, like what representations are being made that would lead people to, underestimate their ability to succeed, given that the market is very obviously saturated. And similarly, you would ask around, if everybody you know is telling you that they're selling this product, that they're in on this participation, then it's something to consider that maybe that might not be the best, that your ability to sell that product is probably going to be limited. Your ability to find new customers is probably going to be limited. And that should give you pause. Along those lines too, any business opportunity that you're going to pursue should have a defined and concrete sales plan. And just like with the terminology above, can you understand the sales plan? Does it make sense to you? And as you read it out, if it's complicated, get someone else's perspective on it. Don't assume that you'll be able to figure it out as you go, because there might be components in that sales plan that work to your disadvantage, that if you knew about at the beginning, you wouldn't want to participate in it. A good sales plan will probably have some types of restrictions and limitations or requirements in there. Do those limitations or requirements make sense to you? Can you live with them? And more importantly, do you think you can be successful given those limitations? There's sort of been already talk about inventory and how much you need to maintain. So just as you're looking at the sales plan along those lines, does it present you with minimum purchase requirements? And do those requirements make sense? Do you feel that if you had to purchase that amount, would you be able to turn around and sell it, or are you going to be stuck sitting with it? We had participants who were like, well, I figured I would be able to use all that product. But of course, that's way more product than a household would need. So in addition to that, ask yourself what under the sales plan are the keys to success? Like, how are you going to make the most amount of money under this plan? Is the plan geared towards how to make more sales, or is the plan geared towards how to encourage other people to make sales? And obviously, if it's the latter, that should be a flag. You're not looking, hopefully you're entering this business opportunity not to create more business opportunities for other people, but to sell products, to participate as a business, not as a recruiting agency. So be aware of that. We had in one of my investigations, we were interviewing a consumer who deemed herself to be successful. And we asked her, well, how do you see yourself becoming even more successful while participating in this business? And her response was, oh, that's easy. I'll just find lots more and more people to also sell it to that I can advise. And if that's how you're deeming success, then you should step back and consider whether or not, this is a business that's oriented around selling something versus oriented around finding more people to participate. This has been talked about as well already by a couple other people too, but look into the representations being made by the people asking you to join. Are they too good to be true? If all you're seeing are the photos of people driving Ferraris and talking about their third home, those aren't the people you want to ask questions to. If you're invited to participate in some type of a presentation about participating in that sort of think about joining this group, and you go to that presentation, the people on stage are likely the ones doing well, but you should ask the people around you. They might be people who are in there and are struggling. And you should ask them questions. It's sort of like if you were to hire a contractor for your house, you'd ask for references, or rather you should. Our office certainly would advocate that. but you should look around and ask other people participating, not just the ones that are telling you to join, but the ones who are already involved. Ask them questions like, how much are you spending on this? Have you made any money yet after expenses? How long have you been in this? At what point do you think you'd evaluate whether or not you're going to continue? How much money have you planned to put into this opportunity? So, you know, we'd recommend obviously that you reach out to people around you that you know, or to reach out to other participants if you were at that type of a presentation, or, you know, if it's a sort of a direct selling opportunity, generally you're likely going to be able to find other people offering that product, right? Making themselves available on the internet. So don't be afraid to cold call a couple of people and ask, like, what's your experience been? How much, but the hard questions, how much money have you had to spend so far? And how much have you gotten back while you're participating? So likewise, along those, like one of the things that we heard too, from consumers that they were told by people that were recruiting them were, present yourself as being successful, fake it till you make it, was repeated to us by, I mean, a majority of the people that we spoke with, both who were successful and who believe themselves to be victims as well. If you hear that phrase being stated, be careful. Like, ask them, okay, how much is it costing you to fake it? Like, how much money are you spending to be a part of it, to participate in here, and how much have you seen back? And just the last thing I'll add, because I know my time is with a minute or so left, is, you know, as with any product that you would buy, do your research. Look online, research online with a critical eye. I don't know that the BBB offers, that the Better Business Bureau in the United States offers evaluations on business opportunities, but you should do your digging around still and see where you can find comments and feedback on it. I'll pass over to Douglas. I'm sure there'll be questions.
Oh, I'll definitely have them. Thank you very much, Jacob. That was very helpful. And I'm looking for Peter Vandernet, who is our next speaker. And Peter, are you?
Doug, can you hear me? Okay, I was waiting for you to allow me.
Yeah. Oh, do I have to allow you?
Well, it said you cannot start because your host has stopped it, but it looks like I can.
Yes, I see.
Okay, that's the message I received, so I'm glad it's void. All right.
We're still finding our way through the mysteries of Zoom. So, but here we are. Thanks, Peter. And I'm gonna get off the screen so you have a full field of opportunity here.
Okay, thank you, Doug. By way of brief introduction,
I didn't introduce you. Sorry.
You don't have to. In the interest of time, I'll just, you know, make my own introduction.
Let me just say, Peter was a senior economist at the FTC. He's worked on more pyramid scheme cases than anyone I know, and he continues to work as an expert witness on government cases, although he retired from the FTC a few years ago. Thanks, Peter, and sorry about that.
Sure, and that's fine. And I'll just add that I'm an economist. I'm not a lawyer, and I have worked on pyramid scheme analysis now for more than 20 years. My own continued work in this area has convinced me over time that while the case-by-case prosecution of pyramid schemes is necessary and that it should be continued, I've come to the conviction that it's actually not sufficient in order to deter preventing the harm caused by pyramid schemes. And I believe that we will need a nationwide rule regarding pyramid schemes. And I'll return to that point near the end of my talk. I have 5 slides to share with you, and I'll just jump in with slide 1 if I can get them up on my screen. Let me try this right now. Let's see, I have to find my own presentation. I thought it was on my desktop, and it is here somewhere. No.
Peter?
Yes.
Let me share your slides.
Okay, if I'll look for a moment yet to see. Okay, thank you, Bill. Thank you, Bill. I will set it up so that can I use share screen in this?
I'm sharing your screen. Go ahead and talk and tell me when you want to go to the next slide.
Oh, okay. Okay. Well, thank you, Bill. let's just start with slide 1. And the thing I struggled with early on is something that I think the earlier speaker, Paul Hanna from Ireland, said, that when he looked at their pyramid promotional scheme definition, he said he wished it could have been written in plain English. And I think that is always an issue. And I, being an economist and not a lawyer, early on had to formulate for myself what is my understanding of a pyramid scheme that can be stated in very plain English and does not specifically reference any particular legal formulation, even though I will be writing an expert declaration in which I often concluded that the organization was a pyramid scheme. And so I would have to have a characterization that I could say plainly in a few sentences, preferably in one sentence. I struggled with that. So I started with a very general description at the top. You see that a pyramid scheme is a perpetual recruitment chain or endless chain, which is a more traditional vocabulary, in which the design of the scheme's rewards to the participants dooms the vast majority to financial failure. And in a moment, I will come back to the notion of endless chain under the California statute later on, because it uses this definition of endless chain. But for my own work in the context of multi-level marketing, I formulated and presented in my early cases the following definition. A pyramid scheme is an organization in which the participants obtain their monetary rewards primarily by recruiting others into the same organization rather than by selling goods and services to the public. I used that formulation already in FTC versus Jewelway in 1997. Please note the name Jewelway, not that other case. And interestingly, Jewelway specifically picked the name Jewelway because it said in its promotional materials, we want to be the Amway of jewelry, hence Jewelway. In 1997, I wrote a declaration to the court and I used the stated definition of a pyramid scheme in the context of multi-level marketing. And ever since that point, I continued to use it throughout wherever applicable, all the way through FTC versus Burn Lounge, both in 2011 and in 2014. Interestingly, in 2014, the Ninth Circuit Court of Appeals reviewed the defendant's appeal of Burn Lounge. In 2011, there was a decision by the district court that Burn Lounge was indeed a pyramid scheme. I had testified in that court. I used, among other things, the stated definition of a pyramid scheme in an MLM context. You have it on the screen. And the defendants, upon appeal, posed what's called the Daubert motion and basically said, my testimony specifically on pyramid scheme was not in accordance with case law. It was my own personal private definition. And in fact, they said it ran contrary to case law. And the Ninth Circuit Court reviewed my testimony, and you see the conclusion of the Ninth Circuit Court in 2014. Vandernat testified about pyramid schemes in terms that do not materially differ from those used by this court in omnitrition. So happily for me, the Daubert motion was denied. That's indeed, you're right, Bill. Let's move to slide 2. In regard to slide 2, the first thing I want to say is that I believe, and I think it's supported by case law, that retail sales are of great importance. In fact, I would say of primary importance to the proper operation of an MLM. And I became impressed in my own thinking, and also by thinking about the case law, that retail sales are really important. The first thing I want to stress is that already in FTC versus Costco, in which of course I had no part, but certainly read about, and Katie discussed this case, right? That is a legal standard, but it becomes clear within the discussion of Costco that the FTC certainly approved of at least one proper version of multi-level marketing. There are other versions, but it directly pointed to one that it definitely approved of, which was a reward system that is based on consummated or actually accomplished retail sales. All right. This is throughout the opinion and order. So it's specifically in the order that if Cascot wanted to continue its operation, it would have to have a reward system based on consummated retail sales. But more generally, there's an extensive discussion of the importance of retail sales in Cascot. All right. And here I just repeat the Cascot definition. Katie and others have already commented on this. This is the formal case law. But Bill, I do want to go back to that slide, to the prior slide, and just point out that, for the record, that is the standard. But when that standard, specifically in Cascot, talked about ultimate users, which is the key phrase, both the opinion and the order characterize ultimate users as consumers who are not engaged in the MLM's business venture. And that, in that category, generally gets to retail customers and retail sales. Okay, and in fact, the opinion noted, the opinion runs like 61 pages. That's an extremely long opinion. Why does it take so long? Because, among other things, Cascot addresses the meaning of endless chains. What's wrong with those endless chains? Well, one of the things that's wrong is that it creates an absence or paucity of retail sales. And in such a context, it is the absence or paucity of retail sales that makes an MLM just an endless chain that is nothing more than an elaborate chain letter device. So I have become thoroughly convinced of the primary importance of retail sales. Let's please go to the next slide. Here, I want to note that there is a famous court case that, in fact, expands upon the meaning of Cascot and greatly emphasizes again the importance of retail sales. A little bit of background. This is a case, Webster v. Omnitrition, and our moderator, Doug, really knows this case. As background, I'll just say this: the Omnitrition company, which was an MLM, claimed that its 70% rule and its 10 customer retail sales rule were just like an Amway 79, and thus are rules that help prevent a pyramid scheme. And here I want to have some quotable quotes from the court as to what the court thought about that claim. All right, the first one is this: the key to any anti-pyramiding rule in a program like Omnitrition's, where the basic structure serves to reward recruitment more than retailing, is that the rule must serve to tie recruitment bonuses to actual retail sales in some way. Right? And the word is tie. And it doesn't say primarily tie, it says it must tie recruitment bonuses to actual retail sales, but in some way. And the court never specified. So it left open, there may be various ways to tie recruitment bonuses to retail sales, but that's what Cascot requires of you, said the court. Further, the court said, in addition, the plaintiffs have produced evidence that the 70% rule can be satisfied by a distributor's personal use of the product. Now, what does that mean? Let me have a little caveat here. In Omnitrition, the plaintiffs produced evidence that under Omnitrition's version of a 70% rule, it meant that if the distributors themselves certified that they had consumed 70% of the product, that would meet their 70% rule, and by that fact would alleviate the entire allegation of pyramid scheme. That is quite a change. Now, of course, in the Amway case, for those who know the Amway case, the 70% rule never referred to the personal consumption by distributors. It never referred to that. But in Omnitrition, it was extended to mean that, and that's important because there are many cases where the 70% rule degenerated into the following statement: the distributor has to affirm that 70% of the prior purchases were consumed or sold. That's all it required, as in Equinox, where I testified. Consumed by whom? Sold to whom? Equinox's 70% rule, like in Omnitrition, didn't particularly say. So if it was consumed by the distributors themselves, 70%, well, that met the 70% rule. And the court says if Cascot is to have any teeth at all, such a sale cannot satisfy that the requirement that sales be to the ultimate users of a product, which I paraphrase as saying the 70% rule does not identify the ultimate users. that rule was meant for the prevention of inventory loading, and others who know this case understand that very well. Furthermore, the court says, point 3, the 70% requirement can be satisfied by non-retail sales to a supervisor's own downline. This makes it less likely that the rule will effectively tie overrides, which are the bonuses, to ultimate consumers as COSCOT requires. Again, to the point that the first point, you have to tie your recruitment rewards to actual retail sales, or in another language, consummated retail sales. Okay, I want to point out here that this latter review, that in Burn Lounge, a case where I testified, it again totally addresses again this Ninth Circuit decision in 1996, and the Nutrition Court in 2014, excuse me, the Ninth Circuit in 2014 fully affirms Nutrition 1996 as their ruling, and in fact, the Ninth Circuit identified the COSCOT test and called it the Nutrition test. Okay, so that's the affirmation of this ruling, and thus these kinds of quotes. Again, I'm not a lawyer, but I can read the plain English, and the import is quite clear. So please, let's move on to the next slide. Okay, so that is slide 3. We are now, I want to comment on the variation in state laws on the meaning of a pyramid scheme. This is a tough problem because any government agency, whether state or federal, will have to define the meaning of pyramid scheme if it's going to have a law against it. So California, I'm not going to read all of these for you. They're on screen. I think they're highly visible. I'll make some comments on them. California defines the meaning of endless chain. An endless chain, in its intuitive meaning, is exactly A recruits B, who recruits C, who recruits D, and in an endless chain, there is no presumed limit to such an ongoing recruitment process. And so that's the meaning of an endless chain. It's more formally stated here, but the California statute says, okay, endless chains are illegal, and under that statute, it prosecutes pyramid schemes. Okay. Interestingly, for those who care about this topic, the court in Nutrition 1996, the Nutrition Court, which is the Ninth Circuit, stated in section 5 of its opinion, part B, that the California Penal Code 327, and that's what's on screen here, it says this definition is equivalent to, if not identical to, COSCOT. So the court says this is a good definition, although the language doesn't look like COSCOT, and in fact, it doesn't even use the language of COSCOT. The court says, the Ninth Circuit, this is equivalent to, if not identical to, COSCOT. So
I'm really sorry. We're bumping up against our Q&A time, but if you can.
Okay, let me just quickly then say, in the Illinois statute, you notice the use of the word primarily, and I see the Illinois statute as essentially in line with my own understanding and my own testimony. And if you look at that later, you will see that I believe there is a strong concurrence. Okay, the one that I put on screen here is Virginia, which I think, although it begins with certain language that is familiar, and it uses a concept of primarily, here it's called the majority of which, okay, it ends with a statement which actually allows the participants to consume the product themselves. If you look at that carefully, you will see later upon reflection, this allows personal consumption of the product as a carve out, and therefore not constituting a pyramid scheme. Let's go to the final slide. All of this leads up to the need for, in my opinion, a federal pyramid scheme rule. I quote here, I won't read it, but there are proposals before the House, HR 3409, which basically gave a definition for a nationwide rule. But look at the meaning of ultimate user. Ultimate user means here someone who consumes the product, whether or not the individual is a participant in the plan or operation. So it makes no distinction between distributors and retail customers. No distinction. It is wiped away. And I believe that that would be very perilous. and therefore a federal rule is actually needed to render a uniform and a constant definition, and it could outlaw certain practices. It could get penalties for per se violations of the rule. And the ultimate goal is to go back to cost cut and bring multi-level marketing back in line with a retail-based business opportunity. Thank you, Doug.
Oh, thank you, Peter. And now I'd like to, Dr. Moira O'Sullivan has been monitoring the Q&A column here. And we do have a few minutes for questions for our panelists. So Moira, if you want to take it away.
Thanks, Doug. So
Yeah.
I think one of the most popular questions was, could we get the link for Katie's system to file a report again? That was probably the most popular question on the Q&A.
Actually, yeah, if Jacob and Joe could join us also, that'd be great. Yeah.
Great. And I think somebody shared this in the chat with everyone, but it's K and then my last name, Daphne, D as in David, A, FF as in Frank, A, N as in Nancy, at ftc.gov.
That is very generous of you to do that.
I look forward to hearing from folks.
There are a couple of questions I think we can probably roll into one here, asking about what private sector attorneys can do to help victims of fraud. There was a question more specifically about the relative benefits or effectiveness of AG actions, federal actions, class actions, individual actions, and what your thoughts around that are.
I can start by just saying that I think that everyone who is here at this conference, from what I've seen, folks appearing on the panel, play a very important role in addressing this issue globally. I think that there is no way for one particular type of advocacy or type of actor to solve the problems in this space. And so it's critical that we divide and conquer and people address harms from pyramid schemes in all the different ways that we can with all of the different tools.
I'll just say as to class actions, which is my area, unfortunately, and this was my area, I don't think that a class action is the way that you're going to get real change in this industry. And that's the best thing you can get from a class action is compensation for some subset of distributors. But in terms of really protecting people from future harm, a class action is the incentives are not set up to do that. It's really, I think, something that the regulators have got to do. And again, I apologize for my voice.
That's all. I agree with all that. One thing as a sort of a technical legal matter that I think highlights the fact that these are all separate tools is just the type of relief you'll get under each piece, right? The government are the only people that can get injunctive relief. Our monetary relief is limited to restitution. Private plaintiffs can recover damages, which is more expensive than restitution. So they can all work together, and I think would need to work together.
There were also some questions around what people who were getting involved in an MLM should look for particularly, and obviously Jacob really spoke to this, but would anyone else like to come in on what the sort of key things to consider for potential participants in an MLM are?
I think Jacob's made some really great points, and a lot of those are reflected in the FTC's guidance too, which I mentioned is at ftc.gov/pyramids. There's a lot there because part of the guidance is about if you're interested in joining an MLM and you know what that is, and you're interested in evaluating which one's the right one for you or something. There's a lot of guidance on treating this like a serious investment of your money and your time, and a serious business opportunity that you need to research in many, many different ways. The guidance also, on the other hand, covers how can you try to suss out whether something is not a legitimate MLM, but is actually a pyramid scheme? What are the red flags for that? And so I think both of those two pieces are really important for people to think about.
Great, thank you.
I would also add, you know, I agree with everything that everyone else has said here, but people can also look at our website. The Washington Attorney General's website has pages dedicated to various consumer issues, including a page about pyramid schemes and specifically what consumers should look out for, and questions that consumers might want to ask of people that are recruiting them into an MLM, just to sort of understand what the business opportunity is and whether this might be an illegal pyramid scheme. And I think one thing that hasn't come up, or maybe I missed it, one thing that folks might want to ask is what sort of costs are associated with getting involved, including whether they're going to be responsible for their own sort of ancillary business costs. Oftentimes that's not disclosed, but the company is expecting individual participants to hire their own accountants, you know, their own lawyer if they need legal advice, you know, spend money on printing, things like that that are not usually described, you know, when the business opportunity is being pitched. And that stuff can add up to really significant money and costs that participants are going to have to pay.
I'm just gonna add in too to what Ben just said as well, that in addition to those costs, certain types of schemes certain types of selling or direct selling structures might require as well permitting or registration, depending upon your state or locality. So just those, and those obviously come with costs as well, but then you also run the risk of, if you don't have those, of running afoul of other laws other than pyramid related laws. If you're participating in something that's a direct selling that requires a permit or a license for the area that you're in, that's just something to make sure that you're aware of.
Can I just ask a non-American question? Are we talking about things like
Sorry.
What are you broke up on?
insurance or needing to be a registered agent or something like that? Is that the kind of like as a non-American?
Oh no. So for example,
is that like,
if you're selling like a food product, for example, and you're selling it directly or in an open format, you might, if you're within the limits of the city of Chicago, for example, there might be a certain regs that govern those sales. That would be my example.
I would personally, I don't, we don't have time for this. I would love to see Peter and Katie duke it out over primarily, but that's probably another program. But I want to thank you all for. Well, I guess we have room for one more question. Moira, you have anything else? You froze on us.
Sure. I think again, I think Jacob touched on this one, but some people mentioned price and sort of, you know, making sure that there's a market for things in terms of their price. Did you have any other thoughts on that?
I have to say, in Omnitrition, we found out that the supposed wholesale price of the Omnitrition stuff was equivalent to the retail price that for the same stuff that was being sold under a different name, but was made at the same factory. So there's really, I'm sorry, the retail price that the Omnitrition distributors were supposed to sell at was the same as the wholesale price. So there's no way that those folks could have competed on price with anyone else in the market. And I think it's an underlooked at area, this whole issue of pricing of multi-level marketing products. And it's certainly something that people should look at before they get involved, but they never do. Unless there's any other comments, I think we've reached our close for this session. Again, thank all of you very much for the time that you've put into this and for sharing your thoughts with us. We now have a break for lunch for half an hour, I think, and I look forward to continuing the conversation. Thanks again.
Thank you.
Thanks, Doug.
Bob is asking me, what am I serving for lunch?